Hey guys, today we're going to talk about the originating summons for probate. Well, as you all know, when a person dies with a will, he executed a will before his death. Prior to distribution of the assets, the executor named in the will has to obtain a grant of probate. The executor cannot just bring the will to the bank and ask for the monies. He cannot bring the will, just the will, to the insurance companies or to HDB or to SLA to effect the transfer of the HDB flat or that. You have to get a court order called a grant of probate. So the very first document to obtain the grant of probate is called the originating summons for probate, which I shall call the OS. The OS looks like this. It simply says that the applicant applies for the following orders. Probate be granted to the applicant. Here's what it looks like. Now, before the filing of the originating summons, the lawyer has to conduct probate searches with the family justice courts as well as the High Court, the family division of the High Court, to ensure that no one else has commenced probate proceedings. Most of the time, the probate searches will return a negative result. That means no one has started probate yet. Now, the originating summons is filed together with a document called the statement, which I shall deal with in a separate video. The statement essentially contains particulars about the will, for example, whether the executor is the sole executor or whether the executors are joint executors, and whether the estate exceeds 3 million, blah, 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 details of the deceased. When the originating summons is filed with the court, the lawyer will also have to file a certified true copy of the will. This doesn't mean that he simply stamps the will and says certified true copy. No. According to the practice directions, there has to be a plain cover page stating this is a certified true copy of the will of Tan Ah Kao, dated which date. And then the lawyer has to stamp certified true copy on the front cover page and sign. And the cover page is then annexed to the original will and uploaded together with the originating summons. A certified true copy of the death certificate of the deceased will also have to be uploaded together with the originating summons. Now, Practice Direction 62.7 of the Family Justice Court's Practice Direction states that the original copy of the will has to be brought to the probate registry the next working day after filing of the originating summons. So the lawyer will, he can bring it himself, he can ask his secretary, but the original will has to be brought for inspection the next working day after the filing of the originating summons. Once the court is satisfied that all documents are in order, it will issue a case number for the probate, and then subsequent documents will then be uploaded, such as the oath and affidavit, which I shall discuss in a separate video. So thanks for watching this introductory video on the originating summons for probate.